He made that same comment.
His office is closer than mine.
Okay. Mine is like 100 some miles away.
Yeah, but you drove with air conditioning, right? And also no heels. No, I got down to get in the car and I realized I drove the small person after the big guy.
Recording in progress. Please be seated. Good afternoon, everyone, and welcome to the afternoon session of the Kansas Court of Appeals oral arguments for September of 2022. My name's Sarah Warner. I'm the presiding judge for today's proceedings, and that basically means that I get to keep time. And so if you see me looking at my phone, you know that that's the reason. I'm joined today by two giants of the bench.
No.
So, and then I'm not just saying that because I'm short, but I have the honor of, to my right, your left, serving with Judge Henry Green, who is the longest serving member of our court, having joined the court in 1993.
Thank you. Yeah.
And to my left, your right, joined by Judge Steve Hill, who is the longest serving law-trained judge in the state of Kansas, having joined the Court of Appeals almost 20 years ago, and serving on the district bench for, let's say, decades.
About 20 years.
And I have been serving on the court since 2019, and so we decided before coming in here today that between the three of us, we have 50 years of experience on the court. So with a small contribution, right. But we have read the briefs for today. We've reviewed the record on appeal thoroughly, but today's argument is being streamed online. And so for that reason, I would like to ask the appellant's counsel if he would give a brief summary of the case, about a minute before we get started, before I actually start counting the time. And that way, anyone who is watching this or who may watch it later will have some context.
Okay, and actually I had in my prepared argument included kind of a summary of how we got here today. So I can either do it as part of the argument or just as a warm up before I start the formal argument.
Excellent. Excellent. Well, we'll just see where that takes us, right? But I will be keeping time. We've got 15 minutes per side, so be sure that you ask for any rebuttal that you would like. At this point, I'll call the one case on this afternoon's docket, and that is case number 124511, Bott versus the state of Kansas and the Kansas Highway Patrol. And would the attorneys please state their appearances?
Bert Harper from Depew, Gillen, Rathbun, and McIntyre in Wichita for the plaintiff appellant.
Thank you.
Arthur Chalmers with the AG's office.
Thank you. And will just one of you be arguing?
I lost the draw. I get to.
All right. Congratulations. With that, I'll invite Mr. Harper to the council table. And would you like to reserve any time for rebuttal?
Yes, if I could reserve 3 minutes, please.
So granted. And you may proceed.
Thank you, Your Honor. May it please the court and counsel. Just very briefly, I wanted to talk initially about what the nature of the case is, what I think the impact of the district court's ruling is on Captain Bott's rights under the deferred retirement opportunity plan is, and then do a quick timeline summary of his path to try to get the benefits that the statutes grant him. And then we'll launch into the legal arguments behind those issues if we can. So our view of the ruling by the district court, which was to find that the claims by Captain Bott are time barred by the 2-year statute of limitations, is that it basically finds that when a state agency with no authority to do so first refuses to accept a retirement benefit application by one of its employees, and then influences that employee to ask for a lesser benefit than he's entitled to as a matter of law, they have no obligation to write that. Even when prior to the payment of the benefits begins, they have the opportunity to set the record and set the course right for that employee. The case comes up to you as a statute of limitations affirmative defense asserted by the state of Kansas and by the Highway Patrol, saying that Captain Bott's claims are time barred because he did not file a lawsuit within 2 years after first filing an application for this drop program. The problem that Captain Bott faced, and anyone else in his position faces, is kind of a catch-22 that's created by the entire statutory scheme. The employee of a participating agency must submit the paperwork through that agency, through that department. So Captain Bott had to submit the beginning paperwork through a gatekeeper at the Highway Patrol. Once it gets through the gate, the whole thing is in the hands of the Kansas Public Employees Retirement System, or CAPERS, which is kind of a separate piece, and they were along for the ride at the first part of the suit. But the disconnect between trying to obtain a review at a CAPERS level and the Highway Patrol level was the downfall of Captain Bott being able to enforce his rights. Particularly, he had to first exhaust his administrative remedies with CAPERS, or run the risk that by having failed to do so, he would be barred from a claim against the Highway Patrol for not having exhausted those same remedies. At the same time, while that process is ticking with the CAPERS review process, which gets mired for some unknown reason somewhere along the road a couple of different times, he runs the risk that the clock is ticking on a cause of action against the Highway Patrol. We attempted at the district court level to deal with both of those problems. We believe the method we employed should have been successful, and that's why we're here today. The background of this case is that my client, Captain Bott, worked for the Kansas Highway Patrol for about 32 years before he put in an application to be covered by this DROP program, the Deferred Retirement Opportunity Program, which is designed to be an enhancement to the CAPERS retirement program available to law enforcement and fire workers. Under the terms of the statute, at the time that he was making that application, an employee of one of the affected departments could put in an application for 3 years of benefits, 4 years of benefits, or 5 years of benefits, and it creates supplemental funding. You commit to a particular window of time. You don't get the money unless you can earn until you've completed that window of time, and you never get better off than you will be at the end of that window of time. So he contacted his then supervisor, Colonel Bruce, to notify him on September 22nd of 2016 of his plan to invoke the 5-year option under that plan. And under the terms of the statute, it was his call how long of an application to put in, 3, 4, or 5 years. He said, I'm going to put in for 5. And Colonel Bruce's response is pretty telling as to why we're here. Because in response to Captain Bott saying, I wanted to alert you to the fact that I'm submitting this paperwork and it's for 5 years, Colonel Bruce responded, unfortunately, I have decided to decline your request. It is my responsibility to evaluate what's best for the agency from both a short and long-term perspective. Due to your lengthy tenure assigned to Troop Chi, I don't believe granting your drop request to be in the best interest of the agency as it continues to evolve and look for new ways to reinvent itself. In short, you've been here a long time and your benefit is going to be really expensive, and I don't think it's a good thing for me, the superintendent, to incur that kind of an expense. That's what prompted the encouragement given to Captain Bott.
Council, what steps did what happened after that?
After that, he then kind of mulled over his options. Colonel Bruce said, I'll let you do a 3-year option. I can approve that. And so he induced Captain Bott to opt for the shorter 3-year period. Captain Bott did that, and he did the paperwork for that. And that was submitted around September 30th for our purposes, processes internally with a couple different dates of who's acting on it. So sometime between September 30th and mid-October of 2016, his 3-year option that Colonel Bruce had said, we will allow you to do that, got processed through.
But he didn't ever, Captain Bott didn't ever seek review of Colonel Bruce's decision in that I'm not going to approve the 5-year.
Right. In 2016, 17, 18, that is correct. Before, however, the third anniversary of the drop election, before any amount of money became payable under the drop plan to him, he began to realize, wait a minute, that statute doesn't give the state the option. It gives me the option to pick the time period. And so before that time had run, before the 3 years was up, we began an effort to get that converted to 5 years without success. And so we tried to go down both of the competing paths we talked about. We, in September of 2019, initiated a lawsuit against the Highway Patrol for its efforts to preclude him from making the 5-year election to begin with. But also, we had to start the action with Capers because it rejected his application at that time to convert it to the 5-year application, saying, our hands are tied. You gave us your application. That's all we can do. The Highway Patrol's position is you gave them your application. It's their baby now, not our problem. So that's the two-edged sword he's grappling with. In the meantime, then, the Capers representatives realized, wait, we didn't put a particular mark on a particular paper. We aren't even ripe to be here yet. We need to fix our paperwork. Our lawsuit is pending with the Highway Patrol. So two things happened by the fall of 2019. In December of 2019, the initial lawsuit filed against the Highway Patrol is dismissed without prejudice, and the paperwork gets cleaned up so we can proceed to take the next step of exhausting the administrative remedies with the hope of getting those two things to converge during the saving statute period from having dismissed the lawsuit against the Highway Patrol. Now, a fun footnote to all of this which was not really discussed below because I think it was, no one really raised this issue below. But I want to talk about the savings statute because the calendar gets a little goofy in here. We've got a dismissal without prejudice of a case in December of 2019 that doesn't get refiled then for more than 6 months. Because in the interim, COVID happened. And the Supreme Court rules on the suspension of statutorily imposed deadlines get suspended. So that becomes a non-issue. And it gives us the luxury of trying to get all the horses lined up again in time for proceeding in Shawnee County in the refiled lawsuit. So there isn't a claim by anyone that the refiling of the original suit was not within the appropriate savings statute period. But if you only look at the timeline, that question may pop up. I wanted to get that cleared up. So
the sole thing that we're looking at is that the filing of the suit in September of 2019, is that within the statute of limitations or outside?
Or not, exactly. And at the district court level, although originally the judge ruled, well, let's analyze by digging deeper into this record what was going on with that lawsuit in the 2019 period, because that presented what the court then perceived initially to be a material fact issue that would preclude summary judgment, because he had treated the motions as essentially going outside the record and being summary judgment motions. The state agencies took the position, no, there isn't any material fact that's raised by that because it's a 2-year statute. It started on September 30th, 2016. The statute ran, therefore, September 30th, 2018. And this lawsuit filed in 2019 is just out of time. Our position on appeal is there are 2 things wrong with that. First, it is not a 2-year statute case, it's a 3-year statute case, which means the lawsuit was timely commenced no matter what, because it was filed within 3 years of the magic date of September 30th, 2016. The question of whether it's a 3-year or 2-year statute is dependent upon whether a claim for benefits that was denied or was altered by the agency under the DROP program is a liability created by statute. And that's something I think we need to talk about, because that by itself would dispose of this appeal, send us back, and we'd get to pursue the claim against the agency on that basis.
You're correct. And then trial court found that this statute didn't create a liability by statute. Is that correct?
Correct. Yeah. So the trial court rejected the idea it was a 3-year statute and said it's a 2-year statute, and that the accrual rules did not cause that claim to accrue at any date later than the very date the paperwork was filed. And that's the second issue that I want to talk about pretty soon too. But for purposes of defining even whether it's a 2 or 3 year statute, we need to stop and look at the cases that talk about when you have a liability created by statute. And the examples in the cases that both sides have submitted to you fall into 2 different categories. One, it's a statutory provision on pursuing a common law defined claim. And maybe the biggest example of that in those cases is the case involving a claim under the Kansas Tort Claims Act, which is itself not a special form of remedy. It simply determines when the state is or is not immune from tort claims that arise under common law, other types of statutory claims, but the Tort Claims Act itself creates no new cause of action. It only provides a mechanism for pursuing a cause of action. In contrast, cases involving the Kansas Consumer Protection Act involve claims that are created by statute because they're not identical to the fraud claim. They either have pieces missing or pieces added. The Lawrence case involving essentially a wrongful frisk kind of claim created a claim for that's separate from a battery claim, separate from an invasion of privacy claim, and defines a particular remedy for those violations, liability created by statute. And within the state of Kansas, cases construing what statute applies where there's a claim arising under ERISA, a federal pension plan, and under Kansas law, that is a liability created by statute, and it's a 3-year statute of limitations that applies. This is a claim in which my client was denied a retirement benefit defined exclusively by a Kansas statute. The Kansas Drop Act, KSA 74-4901 and following. But for that statute, there is no claim. There is nothing for Captain Bott to have been trying to receive other than what's provided under that statute. The drop liability is a liability of the state.
Isn't the nature of the liability a little different, though? It strikes me that under like the Kansas Consumer Protection Act, the liability under that act is a violation of the conduct that's defined therein. Whereas here, the liability that Captain Bott seems to be citing is conduct kind of tangential to that statute. That is Colonel Bruce's conduct with regard to that initial interaction.
Yeah.
Isn't that different?
That is it's a valid distinction to look for, because you are right. This is the conduct that we're talking about isn't defined in the act other than someone can apply for the benefits and get it. So you're right. The Colonel Bruce's conduct saying, yeah, I'm not going to let you send your paperwork in, isn't really described there, but this is enough like an ERISA pension plan. We're dealing with a right that is out here. It's a right that is created by statute that doesn't exist otherwise. That's why I believe that that body of law still applies, even though you are right. Technically, the conduct is not defined in that act. The privilege that's being pursued is defined in that act.
I believe that you are to the end of your opening time, but I want to make sure that all of the other questions are asked. So are there any other questions?
Well, yeah, in what we're talking about, I'm kind of confused because then they talk about this identical test, okay, in terming whether 2 or 3 years should apply.
Right.
Tell me, how does that work? Because I understand about is talking about the statute, whether or not it creates a separate causal action. But help me with the identical test when we're saying the court, and I think our Supreme Court was looking at how you use that to determine whether or not.
Well, that test is, for example, under the Kansas Consumer Protection Act, it's been determined that is a liability created by statute because, for example, a claim for consumer fraud or a deceptive act or practice under that act does not have the same statutory, you do not have to meet the same level of mental fault, if you will, to have exposure under that act. Under the unlawful frisk statute, same kind of thing. It isn't just that it's a battery, it's that particular things were done to a particular person that is unique from and has different elements from a simple battery kind of theory. So in this case, again, if the question is there something that's inherent in the Drop Act that is different from what this person would experience at law generally, then
the common law, the fraudulent inducement, is that?
Yeah, well, that gets us then to the fraudulent inducement piece. And if I may go beyond my previously requested 12 minutes, just to address that part quickly. The case consists of 2 pieces, if you will. There's he didn't get the retirement benefit he's supposed to get. And the reason he didn't get it is driven by the actions of Colonel Bruce wrongfully denying his Captain Bott's ability to submit the application. If that is driven by a 2-year statute of limitations, which is the essence of what the district court held, then that's because it's a tort, but that means you bring with it all of the tort statute of limitations concepts, including defining when that cause of action accrued. As of September 30th, 2016, although the form had been submitted, the math hadn't been done, the retirement hadn't occurred, the vesting of the benefits hadn't occurred. That didn't happen until he actually was put in a position to having to start the claims with capers, which is in 2019. So if you look at when did this person experience an actionable harm, that's when the when the dollars start flowing, not when the paperwork gets signed. And that is like the mining case in which a homeowner realizes something's going on and it takes a while to make the connection. It's like a medical malpractice case where someone finds out months later the reason they've been sick for the last 6 months has been because someone left a sponge in their abdomen. It's like the Hecht case involving a legal malpractice case where the things happen, but you have to get through a bunch of processes before the harm is realized. It's like the title company case where title work gets messed up, but no one knows it's a problem until years later. That's what this case is. And that's why the accrual doesn't occur until 2019, not in 2016.
I appreciate this. One more point.
Yeah.
What about when he signed for the 3 years and basically it said it's irrevocable?
Candidly, that's what I guess we can call that a bad fact. The form says that, and there's his signature, big as life. The problem is you then have to look at the circumstances of that. He has tried to get the paperwork signed in a way that he's entitled to, but he has to get it through the gate, and the guy at the gate won't open it unless he changes it. That's the wrongful act of the Highway Patrol. That's what caused the paperwork to be that way. And that became a problem, a measurable loss to him in 2019 at the end of that 3-year period.
Well, thank you. I appreciate
Thank you,
your
and thank you
response.
for your added patience.
Mr. Chalmers, I'll give you a few more minutes in case you want to continue our discussion, but you may begin.
Thank you. May it please the court. I'm presenting argument for both appellees. When you get to my advanced age, you start thinking about retirement, and there are lots of choices that have to be made, and you have to speculate as to what, well, a lot of different things. In the arena of capers, not as it relates to judges, I don't think, but for the rest of us, when you work for the state a long enough period of time, you have a benefit that's large enough that if you continue to work, you're losing money. And so there's an incentive for folks that are still relatively young after a long period of service like Captain Bod, to go ahead and retire. And the legislature looked at that and said, well, here's what we'd like to do. Capers will go ahead and pay what your benefits would be for up to retirement time that you'll take for either 3 up to 5 years. You can make that election. Now, if you say 5 years, you got to work 5. You don't get your money till 5. You take 3 years and you've got to work 3 years. And what happens at the end of that 3 years is rather than losing those 3 years of retirement benefit, they've been put into the drop account, they're paid out, you get some interest if things pay interest on that. And then you can either take that in a lump sum or you can add it to your retirement benefit. That's a choice that an employee gets to make under the drop benefit program.
But here I understand the argument is he was denied that choice by the man in charge of the Highway Patrol. Says, you're not going to get it for 5 years. Most you're going to get is 3 years.
Exactly.
Now, that seems pretty binding to me. If he can't get it for 4 or 5 years, he has to settle for 3 years. Is that an appealable action by the from the employee? And to whom would he appeal?
That would be the question. We have to accept, because of the way the pleadings read, that it is factual that he was told that he couldn't have the 5 and that he, rather than acquiescence, are going with 3. From the KHP's perspective, obviously, they're not paying money. And so their interest is this an employee who we would like to see to continue on in place rather than take an early retirement. But I think there is, based on the pleading, some sort of cause of action that arose at the time that he was told, you can't have the 5, you got to have the 3.
And that's what I didn't understand about all of this, because this wouldn't be, if I understand things, Kansas Highway Patrol money that's going to, it's capers money. Yeah. So
whether it's a negligent misrepresentation by the colonel whether it's some tortious interference with a statutory right with papers. I'm not going to try to parse that out. What I do know is a tort action that arose at least as early as September 30. And if what we want to do is conclude that we wait until the time that the employer relies on the statement by Colonel Bruce that we have to accept was made, and enters the application where he says, yeah, I agree, it's 3 years, that's when the cause of action accrues. That's when he has a right to file his lawsuit. Now,
Before we go on to that, I want to go back to what Judge Hill was asking about, though. When the decision, assuming that we accept this fact, that he was told his 5-year application was denied, is that an administrative decision? Do you have to file a KJRA petition from that? Where does it go if he wants to challenge that decision?
I suppose if I were to walk that path, understanding it's not been presented in this case, maybe I'd look at some sort of agency relation or employment relationship between the state employee and the agency, in which case I guess there probably would be an administrative appeal involved. I don't know, and I don't find statutorily that there is an obligation for either the Highway Patrol to submit the application, or an obligation on Capers' part or a right on Capers' part to insist that it comes from the Highway Patrol. I know that's how it works.
Yeah. Is this all optional on the part of the patrol?
Well, of course, the statute's different now. And my understanding is the way that at least the Highway Patrol is interpreting it is that if you come in today and say, I want to have additional 5 years, and if you qualify, then you can go with 5. Now you got a work file, but you can take that option. The
reason that I keep coming back to this is it seems like if we're saying that that's the date that it accrues, then there has to be some finality to that decision. If it's just a decision and there's no method by which you can challenge it, then how can we say that that's the accrual date?
Well, I think from the lawsuit as it concerns the Highway Patrol and the state, the finality is the date that he commits irrevocably to 3 years. At that point, we may not know the exact number, but what we know is that there are 2 years that he's going to have to continue to work, and 2 years that he doesn't have, if he were to work in some other situation, the money put into the drop. And that, I guess, is the finality with respect to the cause of action that has been alleged that the court found that was barred by the statute of limitations. The LCL case, I think, is helpful in that we can compare what the Court of Appeals decided and then what the Supreme Court looked at when it reviewed the LCA. In the Court of Appeals decision, that's the one involving, I think counsel referred to it as the title work case. So where one has a mining deed that was filed that didn't include, well, it had a deed filed that didn't include retention of the mining rights, the mineral rights. The Court of Appeals said, well, we don't know. There's nothing final here until it came time that you don't get paid your royalties. And because, yeah, you had the title on file, and yeah, the title said that you don't get, that somebody else gets the royalties, you don't, but that is just a paper injury. Works its way to the Supreme Court, and Justice Byers said, no, it's not a paper injury, it's a real injury. Maybe you can sue at that point for a variety of different things, whether it's equitable relief, whether it's for the damages for having tried to undo the, for attorney's fees, trying to undo the wrong title, but you had a cause of action that accrued. And then they went on to say, well, but we're not going to hold that it is recognizable that you had that cause of action reasonably so, just from the title or just by the fact that the title is filed of record. That's what distinguishes that case from our case, where you've got, as counsel concedes, the bad fact, the application that's signed saying, I know that it's 3 years, I'm not going to get those additional two years. Now, try to finesse that problem. The argument is made, well, this is really a 3-year statute. Of course, that 6512 talks about an action upon liability created by statute. And the Guerin case is one, there are probably others, that point out that means the statute does it create a cause of action? Now, in ERISA, it may be an implied cause of action. I don't remember. Certainly, it's in the Consumer Protection Act of Kansas. It's expressly a cause of action statutorily. By contrast, there are statutes that have a express cause of action that still maybe isn't a liability created by statute. And that's when you get to the identical elements test. But you don't reach the identical elements test if in the first instance you don't have either an implied statutory cause of action or an express statutory cause of action. And there's nothing in the DROP Act that creates that cause of action. Really, the complaint here is that we're denied or we're damaged because we've lost some sort of statutory right, not that the liabilities under that statute to illustrate. Man goes in, he wins the lottery. He gives a ticket to his friend, said, "Can you go collect this for me? Because I've got a little problem with the state. I've been paying my taxes and I know they'll offset it." Friend goes in, takes the money from the lottery and then pay back to his friend. And by the way, this happens. Maybe there's a cause of action, but what we know is
Must be a good friend.
not anymore. But there may be a cause of action, friend to friend, but the liability was not one imposed by a lottery statute that, of course, didn't exist at common law. The liability is for the separate, in that instance, maybe conversion or tort conduct. So this is not a case where the 3-year statute of limitations applies. Under the 2-year statute of limitations that accrued, I'm not comfortable in saying it was September 30. I understand the district court's reasoning, which is under 60-213B. It's when substantial injury happens. And I think what she was finding is that, and it was known at the time that application was signed, that the injury took place. It may be that you could say, well, no, we don't know the injury until it's approved by, your application goes forward and is approved by Capers, but it's still outside the 2-year statute of limitations. The remedy here is dismissal. It may not be a happy remedy for anyone in this room, but a choice was made. He elected to 3 years. As far as I know, he went ahead and took those benefits at the end of the 3 years and moved on to another job opportunity. But the fact is that facts and circumstances of this case, the district court got it right, and we asked that you affirm the district court's decision, which effectively granted summary judgment. I think she converted it from a motion to dismiss to the motion to summary judgment. Unless you have questions, I'll sit.
Any further questions from the panel? All right, thank you. Council, you have reserved 3 minutes for rebuttal.
Thank you, Your Honor. I suspect unless the court has more questions, I'll be much briefer than that. There are two suggestions by Mr. Chalmers I do want to address. One, he's not sure that the statute as it existed in 2016 creates a right to the benefit or an obligation to pay the benefit. I was hoping among the quotes in the briefs, I'd find the actual language of the statute. I don't. So about all I can do is encourage you to look at that 74-4986K. It is not a right to submit an application. It's a right to a benefit and the corresponding obligation through Capers then for that benefit to be paid, which gets us, I think, to the other piece that Mr. Chalmers talked about, and that is the sense of whether there is a cause of action created implicitly or explicitly by this act. To find that there is not, at least implicitly, a claim by a person who is statutorily entitled to retirement benefit to take steps to enforce that benefit would be tantamount to saying that no one who is covered by the Capers program would have a cause of action if their benefit isn't paid. That is not how the retirement program works. It's not how ERISA works. It's not how traditional pension plans work. There is a cause of action to get the benefit that you're entitled to. That benefit is defined by the statute, and that's why it's a 3-year statute. Beyond that, I'm open to any other questions the court may have.
further questions from the bench?
Thank you for your attention.
Thank you very much. Thank you for your briefs and for your argument today. It's an interesting case, and we'll take the matter under advisement. We'll endeavor to get a decision out soon, and the court is now in recess.
Thank you.
Thanks for the voice.
Yeah. So, gentlemen.